Hey everyone, welcome to Localism, the podcast that asks whether we're putting our power in the right places. I'm your host and guy who thinks the stuff that goes in Milky Ways is called caramel and not caramel, Balunchli. On today's show, we get into the two proposals I have for an America that has rearranged its system of government around the localist principles. I'm calling these ideas the absolute model and the reformist model. So last episode, we spent a pretty good chunk of time talking broadly about problems with the existing system of American government. To briefly summarize, the federal government is slow and unresponsive, ineffective, beholden to corporate and political interests, and trying to govern essentially unlike regions via a shared system of law that generates conflict. State governments have all of these exact same problems, except that they are in some ways worse, as the federal government's power over local governments is at least limited by the 10th Amendment, while in most states, the state government has total, unlimited power over local governments thanks to Dillon's rule. After that, I sort of set up this hypothetical story about you, the listener, participating politically in a system that had been reorganized around localist principles. The goal was to sort of give a more on-the-ground, daily life perspective of what localism is and what localism is trying to achieve. Then I would spend the next couple of episodes diving into the more technical stuff that was underlying that vision. Hopefully telling a story about how localism works firsthand was an effective way of getting you interested in how all of this localist stuff could work in your community. Honestly, having listened back to the episode a few times after I published it, I'm worried I didn't do the best job I could have for my audience. As I'm sure you all can tell after listening to me talk about this stuff for hours on end at this point, I really struggle to keep from turning what should be a casual, approachable listening experience into a jargon-filled rant. I'll keep trying to give you a better podcast, folks, and please do feel free to reach out to me at localistpod@gmail.com, that's localist with a T, with suggestions on how I can improve the listening experience for you. I take feedback very seriously. Another thing I want to mention, I have a few beta listeners, friends, family, stuff like that are kind enough to listen to my episodes before I publish them. After last week's episode, a few of those beta listeners talked to me about how much they strongly disagreed with some of my ideas for how to fix things in America. I bet some, or maybe a lot of you, also think that the stuff I'm proposing is horrible policy. Look, obviously I think my ideas have merit. That's why I'm doing my best to share them with the world. But it's equally obvious that these are tricky topics and that there are no easy answers for how to make America better. I think it's great that people can have so many different reactions to what we've been discussing, and it adds a lot of value to what we're trying to do here to have people around who will say, no, I disagree, and think a different way is better, or what you're saying is wrong and harmful. If you're on board with the idea of localist reform and rearranging current systems of power to devolve more power to localities, and you want to learn more about the nitty-gritty of what that might look like and the hoops we'll have to jump through to get there, that's great. I really hope you keep listening. If you're incensed by the stuff I'm raising and am convinced that I'm totally off base and delusional and proposing things that would harm you and your neighbors, I also hope you keep listening. Partially because, full disclosure, I'm hoping to convince you to change your mind, but also because if listening to the stuff we talk about helps you identify the parts of America that frustrate you, that you wish were different, and then you feel more motivated to act, that would be awesome, even if the changes you'd make are different than mine. Okay, that very long outro out of the way, let's immediately jump into one more thing that I have to cover before we launch into the main conversation of today's episode. Sorry, I'll get to the point soon, I promise. This episode is going to be about the broad strokes of the absolute and the reformist localist models that I keep bringing up and not explaining. But in addition to those models, one topic that came up during last episode was the system I called proxy-based direct democracy that I depicted in the localist pitch. We'll get into what that system is and why I think it's necessary for localism in a future episode, one that will be entirely dedicated to the topic of proxy-based direct democracy. But not in this episode. As will become clear as we move forward, the absolute and reformist models are the what of localist reforms. What I mean by that is that the models provide the structure for the relationship between local, state, and federal governments in a localist America. In contrast, proxy-based direct democracy is more about procedure, the way things get done and laws are passed in a local government. It's the difference between how do we need to restructure things in the country and state at large versus how do we need to restructure things at home in our community. Today's episode is just going to be about the state and federal level restructuring. Okay, let's get into the main topics for today's show. We'll start by explaining the absolute model. Even though this model is the more radical one, and it also would require the greatest changes to how America currently functions, I think it's actually the simpler one to explain. Basically, the absolute model can be described in a single sentence. Local law is the supreme law of the land. Each local government has final authority on what laws do or do not apply within their jurisdictions. Another way of putting this is that under the absolute model, the current flow of preemption in America is reversed. Local laws preempt inconsistent state and federal laws rather than state and federal laws preempting inconsistent local laws. This is where the absolute model gets its name from. It represents localism in its absolute form, one where local communities have full and complete authority to govern themselves by passing laws that have binding, final authority. Now, this absolute localism is subject to a couple of really important caveats. Firstly, while the absolute model does place ultimate decision-making authority at the local level, that doesn't mean that state and federal governments cease to have the power to make laws. It just changes the structure of how that lawmaking works, such that federal and state level laws become defaults from which localities can deviate or disregard at their pleasure. Having state and federal governance allows local governments to not have to take on the full burden of providing baseline laws for every relevant topic, and leaving other governments to take on that task. This structure is best explained by an example. Suppose we live in an America that has been reorganized along the absolute localist model. The federal Congress gets together, and the federal politicians start talking about how they've been getting messages from constituents about distracting billboards along the nation's highways. So on a bipartisan basis, the two houses of Congress pass a content-neutral law about what things can and can't be put on billboard advertisements. In particular, they ban videos that flash at rates that create risks of epileptic seizures, and they ban the use of loudspeakers that play songs at a certain sound level. Now, in current America, once the federal Congress passed this law, there would be pretty much nothing that a local government could do to change or avoid it. In fact, if a judge looked at the Billboard Act and said Congress meant for this to be the only regulation of the kind of stuff that can be in billboard ads, it might even be the case that the Billboard Act preempted the entire field of billboard ads. This would mean that a local government couldn't even regulate billboards in ways that didn't directly contradict the Billboard Act. In contrast, in an absolute localist America, the Federal Billboard Act would just provide sort of a default or baseline kind of regulation. If a community disagreed with the act, then it could simply pass a law that says billboards can have videos that could trigger epileptic seizures, or billboards can have loud loudspeakers, and then the Billboard Act would be preempted within the local government's jurisdiction. Now, I'm not saying either of those are particularly good ideas. The point is just that local laws preempt all inconsistent federal or local laws, meaning that a community could simply choose to override any federal law it wished by passing an inconsistent law at the local level. Here's another angle of how all this works. Suppose that well before the federal Congress ever considered the billboard issue, multiple local governments across America used their inherent legislative authority to pass some regulations on the stuff that can be on a billboard ad. Then Congress passes the Billboard Act. Under the absolutist model, the Billboard Act would only apply in those places that didn't already have billboard regulations. The pre-existing local laws would preempt the federal law. Basically, what I'm saying here is that local governments don't have to sit on their hands, wait for the state or federal government to pass a law, and then spring into action to override that law locally. The absolute localist model places full legislative authority in the hands of local governments. Local governments can pass laws as they please. State and federal government's lawmaking role is reduced to setting out these defaults that are enforceable only in the absence of local governments using their legislative authority to pass a different law that contradicts the default. That's the first caveat to the absolute model, that state and federal governments still have some legislative authority, albeit legislative authority that's secondary to that of local governments. The second caveat is that under the absolute model, there is still one area of federal and state level law that will continue to preempt local law, which is the area of constitutional rights. That's state and federal constitutions. Now you might be thinking, wait, why are we setting aside rights from the reach of local agency? Localism is all about letting communities make important decisions for themselves via local government, and rights are about the most important topic in all the law. How is it consistent with localist principles to say that the content of constitutional rights is outside the scope of what local governments can touch? I actually think this is such an interesting question and dynamic that I'm going to dedicate an entire episode to discussing it. But in short, the reason why I think the absolute vision of localism should leave rights undisturbed is that constitutional rights are really, really good. They represent areas where we recognize that a government, any government, federal, state, or local, should not be able to act or should be required to treat its citizens in accordance with a certain standard of behavior. Those areas are set in stone to prevent them from being changed due to temporary madness, distraction, or corruption. That set aside, special status of rights is a crucial part of a well-functioning society. I'm not going to lie to you. One of the significant risks that localism, absolute or otherwise, raises is that the status of the law will lose stability. Communities being able to act for themselves rather than wait for Congress means that laws can be passed more quickly. Citizens in localist communities will begin rapidly legislating on topics that previously were inaccessible to them. There's a chance that a whirlwind of realignment will land on a community, and when everyone wakes up, they'll find themselves in a vastly different political world. And if a community wants to do that, if that's the will of its citizens, then they should be able to make that vastly different world. That's what self-governance is all about. But while recognizing that, we shouldn't let a political ideal totally blind us to the real world. It would probably be prudent to find some small area that is worth placing beyond the reach of these turbulent dynamics of change. To warrant intruding on the normal principle of self-determination, that area placed beyond the reach of local agency better be really damn important, like 100% crucial. If this gets touched, society explodes, important. I think state and federal constitutional rights meet that very exacting standard. In practice, how this works is that constitutional rights continue to function in basically the same way that they do now. Constitutional rights will preempt any law, local, state, federal, or otherwise, that infringes upon those rights. Even under the absolute model, where local governments have the highest legislative authority in the land, that authority cannot reach the realm of civil liberties. Now, one way in which localities in the absolute model can legislate concerning rights is to actually expand the scope of civil liberties. It would be fully within the authority of a local government to provide for a new right to its citizens, or to provide a more expansive version of a right that is provided by a state or federal constitution. For example, the First Amendment and many state constitutions provide a right for free speech. That currently allows the government to impose time, place, and manner restrictions on expressive activity. This is stuff like your bullhorn can't be any louder than this amount of decibels, or you need to get a permit for your parade, or everybody has to go home by 11 p.m. Now, under the absolute localist model, a local government could not pass a law that says the First Amendment is no longer in effect. That law would be preempted by the Constitution and also probably the state constitution. However, a local government could pass a law that says citizen right to free speech is extended such that time, place, and manner restrictions are unlawful. That may not be a very good idea, necessarily, but it would be permissible under the absolute model, because the law would be expanding the scope of an existing right rather than diminishing or abolishing that right. Relatedly, a local government could also create a local right that does not exist in a state or federal constitution. For example, a local government could choose to provide a right to housing or a right to food, substantive rights that currently are not in the federal constitution and also are not in any state constitution that I'm aware of. Again, not saying that granting those rights are good or bad ideas, just that it's something a locality could do under its authority under the absolute model if it so chose. Okay, so that's the absolute model. Local laws preempt everything except for rights derived from state and federal constitutions. This is obviously very different from how things work right now. What legal changes would need to go into effect in order to achieve the absolute localist model? We're going to dive into how these changes and steps could be achieved in later episodes, but I'll briefly sum them up here. Basically, there would probably need to be two layers of change. First, the federal constitution would have to be amended to add a new provision that says federal laws, except for constitutional rights, are preempted by local laws. The language would need to be extremely precise in how it defines local governments and in describing the scope of what parts of the Constitution would continue to have preemptive power, but that's sort of the gist of what the amendment would say. Now, maybe a federal amendment that says state laws except state constitutional laws are preempted by local laws could actually achieve that outcome, but I suspect that it would be a huge stretch to suggest that the federal government has the authority to regulate the relationships between state and local governments, and my guess, which could be wrong, I'm no expert, is that a federal amendment that tried to make local laws preempt state laws would create very confusing 10th Amendment problems. I guess maybe you could amend the 10th Amendment while you're in the neighborhood? But getting one federal amendment through was already hard enough, so hard that the political conditions under which that amendment could be passed are almost impossible to create. Adding a second federal constitutional amendment to that process would multiply the difficulty exponentially. So we get to the second layer of change, which is amending state constitutions to say state laws, except for state constitutional rights, are preempted by local laws. This would need to be done in like every single American state. No big deal, right? But unlike the federal amendment, this one at least wouldn't need to be an all or nothing proposition. Even if this reform didn't get achieved in some states, it could still happen in others. It could also go on prior to or concurrent with the movement for the federal constitutional amendment. I'm going to do entire episodes later about how to amend state constitutions and the federal constitution. It's a pretty obscure process, so I think it's worth diving into in depth. Technically, another way to obviate the need to amend a state constitution, that path, which has plenty of its own complexities, is to actually separate a local government or multiple local governments off into a new state that is organized along localist principles. State separation has precedent in American history and is a very interesting potential solution. Not to be a broken record, but this is another topic I'm going to do a full episode on in the future. And that's the summary for the absolute model. How about the less radical alternative, the reformist model? Like its name suggests, the reformist model doesn't try to go about totally restructuring the system of American government. It wouldn't require any action at the federal level, which makes it more achievable than the absolute model, and also means it can be rolled out slowly over time to gauge the model's effects. These pragmatic gains are offset by the fact that the reformist model does not ultimately place final decision-making authority on all matters in the hands of local governments, and it's an exchange of potency for achievability. So if the reformist model doesn't involve change at the federal level and doesn't make local governments the highest authority in American government, what does it do? Good question. Answering that question will be a lot easier if you've just listened to episode 3, which is the episode about the Cooley Doctrine. If you haven't listened lately and you're short on time, then the really important part of that episode is the back half, where I discuss some of the ways that I think the Cooley Doctrine fails to draw the correct conclusions from its own premises. And if you're like me, and there just ain't no way you're going to go back and listen to me drone on about that stuff again at all, here's the executive summary. In his concurrence in the case People v. Hurlbut, Judge Cooley raised all these really fascinating ideas that challenged the prevailing understanding of the relationship between state and local governments. He pointed out that it's not necessarily true that state governments predate local governments, and thereby implied that they had an independent source of authority that did not derive from state governments. I suggested that he was also implying that state governments actually owe their existence to local governments rather than vice versa, which Cooley acknowledged was not the accepted theory of how states came about, but nevertheless arguably indicated was his view. Lastly, Cooley brought up this idea of these unspoken principles underlying state constitutional law. He called these certain fundamental principles in our general framework of government, or something like that. To Cooley, these principles were so fundamental that they didn't need to be explicitly mentioned in state constitutions in order to be effective. The drafters of the state constitutions just assumed that they were so obvious and fundamental that putting them into words was unnecessary. And though Cooley didn't thoroughly explain the full scope of these background unspoken state constitutional principles, he did set out one of those principles, which is that local government is a matter of absolute right, and the state cannot take it away. This was a huge shot across the bow of Dillon's rule, which is entirely premised on the idea that local government is not a matter of absolute right, and is instead something extended solely at the discretion of the state government. It's also inconsistent with Home Rule, which is often considered to have been derived from the Cooley Doctrine and isn't the same in all states, but Home Rule still usually gives state governments the authority to dissolve or override the actions of local governments in most respects. Now, I totally agree with all these takes by Cooley, which is why I was so confused that Cooley ended up joining the majority decision, which is ruling in favor of state-level authority rather than local authority. He also said this other kind of contradictory stuff in the concurrence about states putting the machinery of local governments into place and then leaving it to communities to run that machinery. All that sounded way more like Dillon's rule or Home Rule, so I was like, dude, Cooley, see this thing through. Say what logically follows from all this stuff about unspoken state constitutional law and local government as right and state governments existing due to delegations from local governments. Or at least what I argued logically follows. And here's what I said results if you take the precepts of the Cooley concurrence and assume they're true. Why is it that local government is a matter of right rather than something that the state government can take away? Well, it can only be because the origin of local government comes from somewhere other than state government. Judge Dillon was right about one thing. If states created local governments by passing legislation, then of course states could get rid of those local governments or abridge their authority by amending or discarding the laws that created them. Accordingly, if the state can't get rid of local government, if local government is a matter of absolute right, then states can't have been the thing to create local governments. So what does create local governments? I think the answer is obvious, intuitive, and natural. It must be that the people who live in a local government's jurisdiction, the citizens of the community, who give rise to the local government. These citizens created local governments by exercising their inherent sovereignty, their popular will, to consent to the creation of a government that could manage public affairs in the community for the good of all. And then these local governments, these direct creations of popular sovereignty, went on to create state governments by a second act of delegation. The reason I say that this is a natural or obvious understanding of the relationship between state and local governments is that a similar understanding is at the core of American government. As the 10th Amendment shows, the conceit or theory behind how the federal government came about and how the federal government legitimately exercises its powers is that it's exercising powers delegated to it from the states, which makes total sense. Of course, that's the only way a government could legitimately exist. It has to be based on consent of citizens who choose to delegate some of their inherent political sovereignty. But despite our entire nation being founded on that principle, we don't extend that principle to the state and local level. We pretend that state governments are somehow these special overarching things that have this inherent authority. It would kind of be like if we said the federal government exists because it says it does, and the states exist only at the discretion of the federal government. That should just not be the way things work between state and local governments. So what does that summary, okay, maybe not so much of a summary as an extended sharing of opinion, have to do with the Reformist model? Well, what the Reformist model does is replicate the relationship between the states and the federal government by creating the same dynamic of limited delegated power between local governments and state governments. To put that even more straightforwardly, the Reformist model is just implementing a state-level version of the 10th Amendment, plus a few other odds and ends that I'll explain shortly. It's making it so any powers not expressly delegated to the state government in the state constitution are reserved to local governments. And unless a state government is acting within one of those areas where local governments delegated power to the state government, then the state cannot preempt local actions. In addition to states only exercising those powers delegated to them in the state constitution, the Reformist model also includes two additional carve-outs where local authority trumps state authority and any attempted delegation will be ineffective. In other words, there are two areas of authority that states are barred from, and that local governments will always possess and cannot delegate to the state government. So it might be more accurate to describe the Reformist model as creating a 10th Amendment plus arrangement between the state and local governments. The first of these plus areas is the passing and amendment of local government charters. Local governments will be permitted to set out their own scope of authority under their charters, and local governments can exercise any authority their citizens choose to place in their charters so long as that authority doesn't contradict something in the state constitution or federal law. The second of these carve-outs is matters of local concern. If this sounds familiar, it should. I'm importing the concept from some home rule schemes. The basic idea is that when a local government is passing laws about something that is really about matters within the community rather than, say, an issue that's really something that has to do with the state as a whole. A matter of local concern would be something like zoning. What kind of buildings can be built in what parts of a town or city? But imagine a state that has a big river running through it, and there are multiple local governments that are along this big river. Anything having to do with that river, for example, pollution or fishing quotas or transportation, is something that really needs to be handled by all the people in those different communities coming together and hashing out an agreement at the state level. Now, you might remember from a previous episode that we talked about how this matter of local concern carve-out is actually pretty toothless in a lot of nominally home rule states. For one, some home rule states make it so that local governments are automatically authorized to legislate in the area of matters of local concern, but allow the state-level government to preempt even these locally focused laws as it pleases. A few other regimes nominally make it so local laws on matters of local concern can't be preempted by state laws, but define local concern so narrowly that in practice the protection is very small. You might remember that we talked about this case Black v. City of Milwaukee in a past episode. There, despite the fact that the local action being challenged was the qualifications that the city put on the city's own jobs, specifically emergency services that were part of Milwaukee, the state Supreme Court somehow found a way to say that local job qualifications were really a matter of statewide concern. That's not what's going to happen in the Reformist localism model. Instead, matters of local concern is going to be given a much broader definition that recognizes that communities are more than capable of deciding for themselves how to approach important problems. A matter of local concern for the purposes of the Reformist model is simply any matter that, 1, has to do with the functioning of the local government within its own jurisdiction, or 2, pertains to an issue or problem that is susceptible to being addressed on a locality-by-locality basis rather than necessitating statewide action. I want to be very clear here about what I mean by susceptible. The susceptibility requirement does not mean that a matter of local concern is best handled on a locality-by-locality basis. only that it conceivably can be managed in that fashion. Let's take housing, which is my favorite example. Housing usually isn't just a single community issue. Housing costs are driven by a variety of factors, many of which are regional or statewide or even global. It therefore might be argued that an effective way to deal with the issue of housing costs is to take statewide action. Change regulations, provide tax incentives for construction, increase supply, implement rent control, whatever. But just because it might be effective for the problem of housing to be addressed at the state level does not mean that the problem of housing is unsusceptible of being addressed at a locality by locality level. Each community could exercise its own judgment about what solution or solutions are best and implement that solution locally, and the aggregate effect of those local changes could result in solving the housing crisis. So even though there's a discussion to be had about whether state level or local action is more effective in handling housing, that is not the same axis as susceptibility, which instead asks whether local action could be effective at all. The standard is obviously going to create a lot of pretty tough questions and close issues about what is or is not a matter of local concern. There will be some clear cases, and some cases where it's pretty tough to tell whether an issue has to do with the functioning of a local government or a matter that is susceptible to local action. These are issues where exact line drawing is pretty much impossible. But in applying the standard, the policy to keep in mind is that the point of the Reformist Localist model is to devolve more power to the local level, and that the state should be able to swoop in and cancel out local action only when doing so is truly almost the only way to achieve an important statewide interest. The matter of local concern qualification will not, as it so often does in some home rule states, essentially turn into a standard of, is this thing important that we need to keep it out of local government's grubby hands? Importance does not enter the equation, except for exactly the way I'm about to talk about. This will probably already be implied by what I've already said, but I figured I should mention it outright to avoid any chance of confusion. Just like the absolute localist model, the Reformist Localist model would not change anything about the civil rights derived from state constitutions and the federal constitution. Those will continue to limit the actions a local government may take, just as those rights do now. This prevents local governments from abusing their new expanded authority to intrude into areas of civil rights that have wisely been put beyond the reach of any level of American government. For example, the qualifications for local office would obviously fall under the category of a matter of local concern under the Reformist Localist model. But a local government couldn't try and pass a law assigning some disgusting race or sex qualification for who can run for office. If the government tried, it would be preempted by the civil rights we derive from constitutions and from federal law more generally. Yes, federal law more generally. Remember that the Reformist model of localism only changes the relationship between state and local governments. The federal government isn't really involved. Only the absolutist model changes the dynamic between the federal government and local governments. With all of this in mind, what would need to be done to implement the Reformist model of localism? In short, a whole lot of state constitutional amendments. These amendments would need to add in a state-level 10th Amendment to make state government only capable of exercising delegated powers and allow local government to exercise any such powers not so delegated. The amendments further would need to provide for the right of communities to pass and amend their own charters of local government, and would set out the matter of local concern susceptibility standard for where state government cannot preempt local laws. How would this be achieved? Well, two ways. First, through amending the state constitution, which is a different process for every state, although there are some similarities. Second, localities or groups of localities could attempt to break off into new states, and thereafter pass a new state constitution for the new state that set out a reformist localist model. That's a legal process that has been done in America's past, but it's plenty complicated, and it would require running the political gauntlet through Congress. That's the federal Congress. Although it actually would also require running the political gauntlet through the state Congress. So a few of you may be asking, wait a minute, what about Cooley's theory that local government as right and all that stuff already exists and state constitutions as unwritten implied fundamental principles? Doesn't that mean that technically we could just say that those principles have been there all along and start implementing localism without needing to change the state constitution? Look, I'm way out of my depth here, but I'm pretty sure that an express state constitutional amendment is the best way to do this and is probably necessary. Otherwise, you'd have to convince state Supreme Courts to toss out the better part of 2 centuries worth of precedent and legal understanding to start reading state constitutions in a completely different way. I'm not confident that's possible, and I also frankly think it'd be a pretty hard sell to suggest that Cooley was making an essentially localist pitch in his concurrence. Cooley's concurrence and doctrine are useful because they lay out background principles upon which localism can pull, but as we've discussed at length, he didn't build the right edifice atop those principles to achieve any form of what we're calling localism, reformist or otherwise. So that's the absolute and reformist models of localism that I've been neglecting to explain for so long. Hopefully you all could see why it was important to get into some of those other subjects we covered in early episodes before trying to set up these two models. They build off of lessons and ideas that it was helpful to explore first. We're getting close to the end of this episode, but before we go, I want to briefly summarize the two models so that we have some faster working definitions rather than the sprawling explanation I've been providing over the course of this episode. Let's start with the absolute model. The absolute localist model turns the ordinary flow of preemption and turns it upside down. Instead of local law being preempted by state and federal law are preempted by local law. The only exception is that civil liberties derived from both state and federal constitutions continue to preempt any attempt at the local level to infringe upon personal rights. Other than that, local law is the supreme law of the land. Local law is absolute. Now for the reformist model, which is a bit more complicated. The reformist model only touches on the relationship between state and local government rather than turn all of America upside down. Thus, it reforms local government's role rather than render local law absolute. There are three baskets of changes that are implicated by the reformist model. First, it provides a kind of state-level 10th Amendment that makes it so any powers not delegated to the state by the state constitution are reserved to the local government. Second, it gives communities the right to pass and amend local government charters. Third, it allows local governments to automatically have the authority to legislate on matters of local concern, and the state government cannot preempt local laws that touch on matters of local concern. Matter of local concern is defined much more broadly than it is under current home rule schemes, and a matter of local concern is anything that either has to do with the operation of local government or is susceptible to being handled or solved at the local level. And that's the bird's eye view. You may be wondering which model I think is better between the absolute and reformist model. Full disclosure, my biases and my preferences really pull me towards the absolute model. But I bet others disagree, and I do think that the reformist model would still be way better than the way things currently work on the local level. I also think it's significantly more likely to be achievable than the absolute model. So going forward, I'll continue to discuss both models, and will be sure to point out ways that future topics touch specially upon one model or the other. Next time, we've talked about two models for how to reinvigorate local governance via a localist system of government. But assuming this realignment succeeds, and power is devolved to the local level, how will that power be exercised? What are the internal procedures a local government might develop to give its citizens a greater voice in how expanded localist authority is used? Because trust me, anyone who's ever been to a town council or county board of commissioners meeting knows that local government often does a really good job of elevating the interests of a tiny minority of people while giving everyone else the cold shoulder. If we're going to radically reform how much power local governments have, we need an equally radical reform on how local laws get passed and local decisions get made. Otherwise, we'll just entrench all the current dynamics that often make local governments slow, unrepresentative, and even outright corrupt. I've got an idea for what those radical reforms could look like, a system that I've hinted at before but haven't yet explained. So in the next episode, I'm looking forward to me diving into the small d democratic form of local government that I'm calling proxy-based direct democracy. If that sounds interesting, think about following us on Spotify. And feel free to shoot me a question or comment at localistpod@gmail.com. That's localist, with a T, pod@gmail.com. A huge thank you to Kevin McLeod for letting me use the two songs in this podcast, Acid Jazz and Opportunity Walks. You can find these and a bunch of other really great songs on Kevin's website, incompetech.com. And the use of Kevin's music here is licensed under Creative Commons by Attribution 4.0.